Uh, the idea is I don't want somebody, because as said there are only four people. I don't want to, even if somebody misses it, it's my this thing that I will recap whatever we have done earlier classes in a nutshell, so that the person who missed the classes should not feel odd that they are not able to understand the rest of the lecture. So for their sake, we tried to discuss in the previous classes, started with the IPC, and then we said how IPC is a substantive piece of enactment when compared to the other acts, like other code and act, for example CRPC, CPC, and your Evidence Act and all. We said they are little procedural, adjective or procedural in nature, whereas this will give, the IPC will give you the rights and then your liabilities, and it is a substantive piece of evidence. And whenever somebody's right is being violated, there will be another person who will be violating his right. So the person whose right is being violated should have some kind of a grievance redressal mechanism, and similarly the person who is responsible for violating the right should accordingly be given the punishment. That's what is the essence of IPC. And IPC is a very vast code and very thoughtfully been drafted and all by who is the one who drafted this? Any idea? Always advise you to have a bare act by the side, so that the exact wording which will go to define that particular section, you will be it will be very handy if you can now and then refer the bare act, so that you can relate whatever I am saying, you can relate with the words which figure in the bare act. Anyway, now I intend to start with section 30, which says valuable security. Valuable security. Valuable security definition is given under section 30, and it simply says it denotes a document. Let me first read the section verbatim, then try to dissect it, try to understand the crucial points over there, and then again reread the section, so that we'll have a complete grip on the section. Now, it denotes a document which is or purports to be a document whereby any legal right is created, extended, transferred, restricted, extinguished, or released, or whereby any person acknowledges that he has under legal liability or has not a certain legal right. So prima facie, if you read it verbatim, you will feel it is something Greek and Latin, and you will not be able to understand it in one go. Now, what you have to do is read it, bit by bit. Try to understand the crucial element present over there. Now, it says it denotes a document. That means what? The valuable security is supposed or deemed to have all the characteristic features of a document. So, document will have some writing. It will have a signature. That's what we mean by a document, isn't it? Any letter without any signature has no value. Now, a document, if it bears a signature, then we say any paper, if it bears some signature, then we call it a document. And definition of document is given under different sections in a different way. But for us to understand the definition of valuable security, it is suffice for us to say that valuable security is a document in the first place. That we understood. Or it may appear as document, or we can convert anything to document. That's what we mean by purports to be a document. Now, what is this document trying to do? It is going to create some legal right. That's what we said. What is legal right? Unlike personal right, unlike constitutional right, these rights are different. Whenever that right is violated, then you have a grievance mechanism. You can approach court and ensure that your right is been restored back to you. It is been remedied. That's what is meant by legal right. There may be a number of rights, but then what the section says is it means only the legal right. That means legal right, when violated, will have a remedy. You can approach court, you say that my legal right has been violated and I would like to seek remedy for that. So that is the purpose of legal right. Now, the document is going to create such kind of a right. That is a legal right. So what kind of right it is? A legal right which can be created, it can be extended, it can be transferred. You can restrict somebody's legal right. This valuable security is going to extinguish. It can also release a legal right. So it can do any one of these kinds. And then not only that, definition will not end there, but it will extend further. When somebody gives an acknowledgement that he doesn't have any right, even that is also called as a valuable security. So it has two elements in it. Now it is going to create, and somebody is also going to acknowledge. So what is the acknowledgement that he is offering? He says that I have no liability. If somebody gives, I have liability, or I don't have a right. If somebody acknowledges these two kinds of activities, even then that is also called as a valuable security. So one is it is going to create rights. The other one is if somebody gives an acknowledgement saying that I have no right, even that can amount to valuable security. Now, for understanding any section under IPC, it is worthwhile that you should spend some time in reading the illustration. So illustrations and examples are very, very handy in any act or any code, which will give you clear understanding of what is the essence of the section. So let us take an example here. A is one person who is going to write his name on the back of a bill of exchange. As the effect of this endorsement is transfer the right to the bill of any person who may become the lawful owner of it. The endorsement is a valuable security. So what do you understand by it? So we are taking an example of bill of exchange. There is a bill of exchange. Now I owe some person to I owe some amount to a person. Let us say I am A and then I am due some amount to B, let us say. Now right now I don't have money in my bank. So what I do is I'll try to give the endorsement saying that asking B or asking somebody to give money to B on demand. If suppose B comes and then asks for some money which I am due, since I don't have money, I'm putting the endorsement, please you give, and the other person gives, yes, I'll give the money, then that is the assurance. That means now I am the owner, my ownership has been transferred to somebody else, isn't it? See, here before I had the ownership, now I am transferring the ownership to the other person by endorsement, isn't it? So what am I doing in the process? I am only going to transfer my legal right to the other person. So does it not amount as per the definition? It exactly says the same thing. When in the process, if I am transferring my legal right of ownership to the other person, whereby after the endorsement I am making the other person to become the owner. That means I am transferring my right, legal right, to the other person. So that's the reason why a bill of exchange can be called as a valuable security. Now, what we need to understand is document by document we also create. When document, a mere document will not become a security, valuable security. Only some addition, if it is made to that, then it is going to be converted into a valuable security. What is the extra feature that a valuable security has got in comparison with the document? It is only trying to, a mere document may not create a legal right, but then the moment you transfer your right, or you extinguish your right, or the moment you restrict your legal right to somebody else, then that becomes a valuable security. Now, can we say that every document is a valid valuable security? Can we say that? I want everybody to react for that. Can I give a general statement saying that every document is a valuable security? Can I say that? By definition, if you understand, can I say every document is a valuable security? Can I say that? Is it right if I say this statement?
By definition, I doubt, ma'am.
What does definition say? It is a document. It starts with the premise that it is a document. That means Every document, in order to, if the valuable security has to be there, first it has to start as a document, isn't it? But
Yes.
document per se cannot be called as the valuable security. There is other additional feature also to be added. That means every document is not a valuable security. If I say they both are equal, then I am wrong. If I say every document is not a valuable security, then I am right. Isn't it? Is that clear?
Yes, ma'am.
Now, what is the reverse? Reverse of it. All valuable securities are documents. If I say that, am I right? Reverse is right, isn't it? So it has
Yeah,
to
all
start as a
valuable securities are
document.
document.
Valuable security will have all features of a document. There is no additional thing that we have to do, isn't it? Valuable document is
Yes.
in its full form of a document. You need not do anything to it in order to make it a document. First place, it is a document only, isn't it? So the reverse is correct. That means all valuable securities by nature are documents. But reverse is not true. You cannot say every document is a valuable security. Every document is not a valuable security, but the reverse is true. So by that, what you understand is this a document is a very big definition. That is, it's a genus, and whereas your valuable security will be a species of that. Understood that? Now, so by this definition, we have to see what are all the examples which we can quote in order to say that this is a valuable security. Now, can you say your passport? Is passport a valuable security? Are we going to create some right in that? Yes, Arya, Shubham. When I say passport is an example of valuable security, whether the passport is fulfilling all the characteristics of a valuable security or not. Why that is given as an example for valuable security? Yes. Answer may be wrong or right, but I want you to attempt at least. I am not going to rate your acumen based on this, but some participation is required.
I think passport is a valuable security.
Huh. If you say that, you should also give me the justification. What kind of right it is creating? Is it creating legal right, or is it creating some personal right? What kind of right is it? Can it generate? Because we are interested only not all rights. As per the definition, it has to create only a legal right, or it can transfer right or restrict right or whatever. So whatever words that are figuring in the definition, it should be able to do that for me. Only then I can call a passport or any other document as a valuable security. So what kind of right is it generating when I say passport? What is the legal right there?
There is, I don't think there's the legal right as such, but
But we are interested in legal rights only. So it is
yes,
permitting. Permitting to leave the other country is a
yeah,
freedom to move. Freedom to
yes,
move to any place is being restricted. So if you have permission, if you have passport, if you have that right, legal right, only then you can move to the other country. Isn't it?
yes, ma'am.
Passport is a document which permits you to leave the country. Isn't it?
Yes, ma'am.
So that is a legal right again. So legal right it is giving us to move, isn't it? So that's the
Yes,
reason
yes,
passport
correct.
is a, you can give that as an example for valuable security. What about the lottery ticket? Arya, are you there? So my point is, how can you say lottery is lottery ticket is also a valuable security? If I say,
Ma'am, since it is legal in India, maybe because it is, since lottery is all now legal
who
in
said it
India,
is
I think,
illegal? Lottery is not illegal.
yeah, ma'am, I'm saying lottery is legal.
Not only
Since
India,
lottery is
everywhere it is
legal in
legal
India,
only.
yeah,
हाँ.
since it is legal, so I think it is a valuable security.
नहीं नहीं, just because it is legal it is valuable ऐसा नहीं है. What kind of right it is creating, that's what we mean, because it has to create, no. Out of the
Yeah,
words that
correct.
have been given, it has to either create, extend, transfer, restrict, extinguish. These are all the words which we have used, isn't it? So it should be doing any one of these things. Legal right, I say, per se is not the thing. It has to be transferred, it has to be created, it has to be restricted. So what kind of action is going to take place in a lottery ticket? What is that it is going to create? If your number appears in the newspaper, if you are the lucky winner, now what will happen? You will be bestowed with that amount, prize amount. Don't you become the owner of that money?
Yes,
Is it
ma'am.
not creating the ownership?
Yes, correct, ma'am.
So ownership is a right, legal right. So, and there is a rider there. Only when your number wins, only then you are entitled for that amount. Otherwise you are not. That is the meaning of lottery anyway. But then once you win, in case if you win, again that guarantee is there that you are the owner of that entire amount, isn't it? So that's the reason why in the example we also give lottery ticket as one of the valuable security. Now, what are the other attributes of this? But documents which confer no legal rights, can we say that they are not valuable security? वही है ना, valuable security we can say only when it can give you some right, legal right. If there is no legal right attached to that particular document, it remains as a mere document only. You cannot just say it is a valuable security. Am I clear about this? So it has to be, it has to do something with the legal right, either transfer, either create, extinguish, release, whatever extent. So these features should be there, are associated with the legal right, isn't it? Now,
Ma'am,
hmm,
ma'am, can we consider mark sheet or ID card as a valuable security?
you tell me the difference between a marks card and marks this thing and your ID card.
Ma'am, mark sheet creates ownership.
What ownership?
That
No, no,
that
ownership, see, ownership with regard to property, ownership with regard to some property, some right, isn't it? What kind of a
yes,
right do you mean to say that? As if the document is your own, that much you can say.
yeah,
Marks are your own, only indirectly you can infer that. Indirectly you can infer that since marks are, the sheet is on your name and that document will belong to you, that much.
yes, ma'am.
And with regard to identity, of course, it will reveal your identity and your legal right. You declare that you are yourself. That itself is a right, isn't it? So it is creating a legal right, and yes, it can also be a valuable security as per the definition. If you go strictly by the definition, that can also be construed as a valuable security. Then, where exactly in the IPC sections you find these kind of words? That means valuable security, you should find it somewhere in other sections also. That is the reason why we are studying that under definition. Otherwise, we don't venture to do that, isn't it? Now, let us see what are all the sections in the IPC where this word valuable security is appearing. Now, I can give you examples of 327, 329, where it says voluntarily causing hurt or grievous hurt. In these words, they have given they have used the word valuable security. And this is to extort. Extort means you keep somebody under the fear of threat and then you demand for money. That is called extortion. So in the definition of property, they have also included this. That is, valuable security also has been included. So if you want me to read the section, I can just read that particular only one section and will tell you exactly what that means. 327 IPC, I'll just give me, then I'll say 327 is it is reading like this: voluntarily causing hurt to extort property or to constrain to an illegal act. Now it says whoever voluntarily causes hurt for the purpose of extorting from the sufferer or from any person interested in the sufferer any property or valuable security. So the word valuable security is used in these sections. So unless if you have to understand 327 in a better way, it is but natural that you should understand the definition of valuable security first. So, for that reason, it is important that you should understand first the section, definite section, definition section, that is valuable security. And in other sections also, 347, 348, 420, so 467, in all these sections, somewhere in this section you find the word valuable security. So whenever the valuable security word has been incorporated in any of the sections which are there in the IPC, so it carries the same meaning. It will not, unless until the section explicitly says it will have a different meaning. Otherwise, it is implied that the same meaning will be carried throughout. Wherever that word appears, the same meaning can be attributed to that word. Now, coming to the other definitions, the one which is very important from examination point of view and for understanding other sections is called the good faith, which is appearing in section 52. So 52 section says, and it talks about what is known as good faith. So it plays a very important role in the law of crimes, and it simply says that nothing is said to be done or believed in good faith which is done or believed without due care and attention. Now, if you see and examine thoroughly, you can understand that this particular explanation is exclusion. That means it starts with negative things. So we know in mathematics that two negative things when multiplied will become a positive thing. So since two negatives, it starts with nothing is said, then it will say without due care and attention. That means what you have to understand is good faith is equal to care and attention. When somebody does an act with care and attention, with due care, caution and attention, if somebody does it, then you are bound to be called as doing a particular act with good faith. That means you have taken whatever due care that has to be taken, whatever due attention that has to be paid. You have done these two, you have kept these two things in mind. That means your particular act, when you keep these two things in mind, that implies that your act is with good faith. That's what you need to understand. Now, its presence is ordinarily an answer to a charge of criminality. If somebody, suppose, is under the charge of some criminal liability, then if you can prove that you have done that act instead of with criminal intention but with good faith, that means while performing that act you have taken due care and you have paid all attention whatever is required 100%, then your criminal liability which is attributed to you otherwise can be waived off, because you are proving yourself that you have exercised all the care and attention that is required to perform that particular act. And in spite of taking care, in spite of paying the required attention, if some act is happening, then it is only out of misfortune it can happen, or it can be an account of some accident it can happen. But it is the act of God for which you are not responsible, because you are proving or you are showing the evidence that whatever due care, whatever due caution, whatever attention that you need to pay, that you have diligently done that, and thereby your bit of the action you have done it with all perfection, so no criminality can be attributed to you. That means you have done this act in all good faith, is what can be inferred. Now, then the definitions here given is therefore the keynote. So whatever definition that we are giving for good faith, that it is nothing but care and attention, you can see in most of the cases and sections this particular good faith word occurring frequently. So it has to be properly appreciated. Only when you understand what is the exact meaning of a good faith, probably in further sections you can, whenever that word good faith appears, you can understand it in a better way. Now, I said exclusion and negative meaning. Two negatives will become positive. So, what is the understanding? Good faith is equal to care and attention. That's what we need to understand. Now, in other sections, it doesn't, as far as this definition in IPC is concerned, nowhere in the definition, if you see, the word honesty is there. Honesty and good motives are not at all figuring in the definition that is given under IPC. But nevertheless, I said that the same definition, if it appears everywhere, same meaning cannot be attributed. Suppose, for example, there is another act, General Clause Act, enacted way back in 1897. So the definition that is given for good faith under that particular act has some other meaning. Now let us try to understand what is the difference between the definition. But I'm afraid if you say, just keenly observe the section, it says good faith, if you take care and attention, you are deemed to have taken good faith. You have deemed to have done that act in good faith. That's what it says. But nowhere in this section you will see a definition kind of a thing for good faith. That means you don't find any definition in IPC. But then where do you get the definition for good faith? That is given in General Clauses Act 1897. The purpose of General Clause Act is that wherever the definitions are appearing, the idea was to keep all those words in that act. But the definitions are so varied, so many in number, that in spite of acting the General Clauses Act, also still we find that some definitions they have no place in the General Clauses Act. And whenever we enact a special act, we thought that definitely there should be some chapter, namely chapter 2, under which we have to give the definitions. The reason is General Clauses Act, it doesn't encompass the entire definitions which are available in the universe. So General Clauses Act, though it is enacted, but still in all other acts also we see that we also have a chapter 2 for definitions. Now under General Clauses Act, under section 332 subsection, we get the definition for good faith. So what it says, a thing shall be deemed to be done in good faith when it is in fact done honestly, whether it is negligently done or not. So you get a very definitive kind of a definition under General Clauses Act, though not in IPC. You have this in General Clauses Act under section 3 subsection 32. So it also includes two more words, that is honestly and need not be with all care. It says even if it is done negligently also, as long as there is an honesty element in that, you are said to have been done that particular act in good faith. So this definition is a little in contrast with what is said under the IPC. It says it should be negligent is opposite to care, isn't it? So when you say that you are doing an act with all care and attention, care and negligence cannot come in the same transaction. If you are taking care, then that means the element of negligence is not there. Or in contrast, if you are doing a particular act negligently, then you cannot say that I have also taken due care. That can happen only in under a special condition called accident or misfortune or act of God. Only then you have no control. Even if you take care and attention also, still that thing happening, you can attribute only that to a misfortune, isn't it? So except that, you cannot have in the same transaction or in the same act both the elements appearing, namely the negligence and then care. Because since they are opposite, they are mutually exclusive. So you can't say that negligence and attention can be same, can be there in the same transaction. So the definition under General Clauses Act has got an element of honesty. It says even if you do a particular act, as long as you are honest, even if you do it negligently also, even that is called a good faith, is what is given under the General Clauses Act. Now, what does that mean? This only means While an honestly, when you are doing, even if you do it stupidly also, it can be excused. That's what it means. Then under General Clause Act, it may not fall within the definition of good faith under IPC. So under IPC, we are very clear about it that only attention, care will only amount to good faith. Honesty, dishonesty, I mean, doesn't matter. Dishonest, honest is not figuring there. But in contrast, it says that care and attention. Whereas in General Clauses Act, you see the word negligently, even if it is done negligently also, as long as that honesty is there. So to understand this better, we can take an example. What is that example? Now I'm a drunkard. Now I have attended few classes of first aid, and I have not mastered first aid. But then I saw in some occasion my friend becoming breathless. So with my knowledge, meager knowledge that I acquired in attending few classes of first aid. So in one of the classes, I was given instruction. I was told that mouth to mouth respiration will restore somebody. If somebody is breathless, if I give artificial breathing to him, then you can make him survive. If that is the knowledge I have got, then what I do is, I'm a drunkard, I'm a boozer, every day, every minute I drink, and then not knowing, not keeping that point in mind, I started giving mouth to mouth respiration to my friend. What will be the result? Now, instead of helping him, I would have hastened his death. That means I am an alcohol myself, and my breath will be concentrated in alcohol. And then, if I give that alcohol like breath, then what will happen? It will only promote the death of the other person. Now, can I become criminally liable for this person's coma or person becoming unconscious? As per General Clauses Act, definitely not. Why? Because with all honest and with an intention to make my friend come out of the danger, I am doing this in all good faith. I have no intention, no ill feeling, no criminal intention. I am doing it with honestly. But then my act is stupid. So why is it stupid? First place, I am not an expert to do the first aid with meager knowledge. Number two, I have not mastered it, and that too, I'm a drunkard. I have forgotten that point that I'm a drunkard, and in all likelihood, my breath will carry lot of concentrate. It will be concentrated with alcohol. I forget this, and it is a stupid act. Don't you think it's a stupid act? Stupid act, and then thinking that I'm helping my friend. In fact, I'm causing more and more danger to my friend. So this is the best example to understand an act as both honest and then also at the same time stupid. So this is what you need to understand. So that is the meaning that is attached in the section 52. 52 doesn't speak about any honesty. It only says only two elements, care and attention. As long as an act is associated with these two behaviors, that is attention, care, if you take while performing the act, then it is said that you have done that particular act in all good faith. That's what it means. Now, if you want to understand the elements of good faith, the best case study that somebody can quote is Harbhajan Singh versus State of Punjab. So the element of honest, which is the introduced by the definition of the code, there is no doubt that the mere plea that the accused believed that what he stated was true. It is not your belief. It is not your belief. What actually is the belief that matters. What actually is the belief that matters. Not your own imagination or your own interpretation of belief is going to matter for that. Now this is what you need to understand, and we have done with good faith. So far we try to understand the definitions of the valuable security, number one, and then we also try to dwell on the good faith. Now what good faith is, when somebody is said to be acting in good faith and all, we have understood. Now the other point for us to understand is the definition for injury. Now, the section that deals with injury is mentioned as section 44. Now, as I said, let us first read the section verbatim, then try to understand the key words that are present in the definition and try to understand them. Then again, after understanding the meaning attached to each word, then again we'll give a rethinking to that and then read it once again so that we have a complete grip over the section. Now, we know that the meaning that is given under a legal terminology, or when it appears as a legal terminology or legal definition, you cannot attribute the same meaning to that word as it is appearing in the dictionary. So dictionary meaning is something different and the legal meaning of the same word will be something different. So by injury, what do you mean? A bodily injury. If somebody is inflicting an injury, it can be a bruise, it can be a laceration, it can be an incised wound. So any wound which is created on the body, normally the dictionary meaning is that when you say injury. Now, when the same word is used as a legal terminology, the meaning is little wider. That means it is going to include some more things as the injury. So what are the additional things that we can construe as injury if you see to it? Now 44 gives a very wider definition for injury. So what does it include? It includes not only bodily harm. Bodily harm, we have understood that is some wound, some injury created on the body. That means it can be a bruise, it can be an incisor wound, or it can be a wound which is a sharp created by sharp weapon and all. And there can be many wounds that can be created on the body. So they are called bodily injuries. Now, as I said, definition of injury under 44 is little wider. It not only covers bodily injuries, bodily harm, but also harm to the mind. Harm to the mind psychologically. If I am getting affected by the by somebody's words or somebody's action, then it also includes the injury to the mind, harm to the mind. Now, harm to my reputation, because I'm a senior citizen and I'm an experienced person. By virtue of my experience, I have gained some reputation and some name, fame in the society. And then if somebody is trying to spoil my reputation, definitely that is going to prick me, and that can definitely be added to the definition of the injury. So keeping that in mind, the legislators rightfully have included even reputation as one of the elements in the injury. If somebody is trying to damage my reputation, he is said to have injured my reputation. So that's the reason you find even reputation as one of the things which can be included under injury. Now, not only reputation, property also. If somebody is trying to damage my property, even that person is said to have done injury to my property. So what are all the things that are included in the injury? We can include the bodily offenses, bodily harm, harm to the mind, harm to the reputation, and then also to the property. So whenever we say injury, it implies the injury to all these things, including the property. The injury in section denotes any harm, that means illegally caused. Only thing that is important for us to establish is this particular thing is caused willfully, illegally, which is not legally bound, but yet you are doing. That means this is illegal, illegally caused, and includes any torture. So harm is otherwise a torture, isn't it? Any kind of a torture, even if it amounts to a small degree of torture also, it can be construed as injury. Unlawful detention of a cart at a toll gate. Now, you are passing through a highway and there comes a toll-like thing. It may not be real toll. Somebody putting up a show that it is toll, and then he is demanding money. No, you tender me that toll money, or else I will detain your cart, or else I will detain your vehicle. If somebody comes out with that, then it is illegal demand, because it's not a true kind of a toll that has been erected, and you are only staging a kind of a toll, and on that pretext if you demand money, and that amounts to illegal demand of money, and hence you are attracted under the definition 44 for injury. Now similarly, I know that a particular decree has to be executed, only then it will have meaning. A mere degree position will not give you the property back to you, or your right back to you. So it has to be executed again. I know that I am a lawyer and I have knowledge of law. So what I do is, a gullible innocent client I'll approach and I'll say, see, this is a execute, this has to be, a decree is in our hand now, this I'll execute, and for execution you have to give me money separately. It's not part of my fees. You have to give me some other some further advance, so that I can again put up the case in the court, and then I'll ensure that this decree will be executed and the property can be yours. So but the fact remains that the decree is non-executable decree. So even if you go with the decree also, no civil court is going to entertain that and give you the execute that, because by nature it's a non-executable kind of a decree. So you are deceiving the person. Are you not deceiving the person? You are deceiving the person. Even that amounts to injury, because injury definition includes property also. So a non-executive decree, if somebody is taking, and then if somebody gives an assurance that I'll ensure that your decree is executed and you get back your property, if somebody is giving you that kind of a false promise, even that can be termed as an injury that has been created to a property. Now, the illegality of the harm is the gist of the offense. What you need to understand is, any harm, if you are doing in good faith, that is okay, but then harm willfully, illegally if you are doing, then that is definitely an injury. So illegality is what matters. It is the main principle behind the injury. Now if the injury is not illegal, what does that mean? It's not injury at all as per the definition. So in order to be termed as an injury, it should be illegal. The act itself should be illegal. Otherwise, any legal act cannot be construed as an injury. That's what simply it means. Now, it implies any illegal act or omission. When you say act, it also includes omission. So, an injury may be caused to a person through another, as in the case of adultery. So, even in that case also, you are taking away somebody's wife. You are taking away somebody's wife, and then you wanted to have a illicit intimacy with that. So that means that also can be, adultery in a way can also be construed as the causing injury to the other person, other husband, from whom you have taken away his wife. So that person will suffer an injury, isn't it? Now, as in the case of mischief and theft, so in these two types of cases also, you see the element of injury being involved. Now, when A takes away B's cattle and decline to release them until he is paying some amount, some 50 rupees and all. So the detaining of somebody's cattle itself is illegal. Now on the top of it, that's also, cattle is also a kind of a property. Now you are taking away the property of somebody else, and that too with a which is illegal, and top of it, when it becomes illegal, not for mere detention, but then you are giving a promise that I'll release them only on payment. That is illegal. That part of the act is illegal. So you are illegally demanding for money for the release of the cattle who were otherwise detained by the person who is demanding the money. So in that case also, it is said to have been done with a purpose of causing injury. Now we have done with injury also. Now moving on to the other definition under section 39, called as voluntarily. Now it again depends on cause and effect. For every cause there is an effect. So if the effect has to be, if you wish the effect has to be good, then the cause which results that effect should also be good. So this is the cause and effect equation. Now a person is said to cause an effect voluntarily when he causes it by means by he intended to cause it, or by means which at the time of employing these means he knew or had reason to believe to be likely to cause it, are the definitions. Now what we have to concentrate in this definition is, now when can you say or when can you call somebody doing a particular act voluntarily? Means that your intention is 100%, you wanted to do it, that is number one. And number two is that you have a knowledge, if I do this particular act, that is going to result in a definitive effect. If you have knowledge about that, then you also is said to have done that particular act voluntarily. And not only that, the third element is reason to believe. So all your observations, all your previous experiences, all your previous conduct will go to prove that there is enough reason, enough logic for you to believe that this particular act is in all probability will result a particular desired effect. If you have this particular thing, knowledge also, in that this is not called as exactly knowledge, but this will be called as reason to believe, reason to believe. So any of these three elements, intention, knowledge, or reason to believe, if these elements are there in your act, and if you have a strong desire or intention to do that particular act, and you have pretty knowledge, you know 100% that this act of yours is going to end in an effective in an effect or in a casuality, you know that it is going to happen, or you have reasons, you have previous experiences or reasons or observation to know, yes, it may likely to happen. If you have all these elements in your act, then it is said that you are doing that particular act voluntarily. Now let us take an example and let us understand it in a better way, because I told you always illustrations, examples are very, very helpful for us in understanding the intricacies that are involved in the section. Now the example here given is, A is a person and he is setting fire. Where is he setting fire? He is setting fire to an inhabited house. That means he knows that some people are living in that. A house becomes inhabited when some people are living in it. So it is an inhabited house. He knows about it. Now, when is he setting fire to that house? At night. So he knows that at night there will not be any traffic, nobody will be watching, and his job will become easy. Now, what is his ulterior motive? What is the final aim of that person? Because this house, the house which he wanted to put on fire, is in a town, and there are large number of houses also present in this. Now, what is the ultimate ulterior motive of this man? Is to rob. His main motive is not to set fires, but the ulterior motive, ultimate aim of this person who is setting fire is robbery. So is there any logic why a person who is intends to commit a robbery, why should in the first place waste time, put on a fire, a house, inhabited house and all? What is the purpose? The logic is very simple. Now when everybody is there watchful, then he will not execute his act of robbery. Now his act of robbery, his action of doing a robbery will be easy for him, when he commits it, when people are hanky panky, when they are running helter shelter, then there is nobody will be vigilant, everybody will be interested in putting off the fire or extinguishing the fire. So that way all their houses will be open, and it will be easy for him to go and enter each house, and whatever little valuables they have, it can be easily be stolen, it can easily be robbed. So that is the idea, final idea. So with that idea in mind, what this person A does is, he sets fire to one of the houses that are there in the located in the town. Now all other neighbor houses, so they become alert once the fire is there. So they run towards that house, thinking that they can put off the fire and all. So whatever occurs to their common sense, they try to do that by all means, and then they are busy doing that. Now, meanwhile, this gentleman, what he does, he goes to every house, loots everything, and then comes out. That's how it facilitates him for doing robbery, isn't it? Now, what is the liability, criminal liability of this man now? Here, A may not have intended to cause death. See, his intention is not to cause death. His intention is not to cause death. His intention is, final intention is to rob the house. Isn't it? It is so incidental that somebody died. But can you say, if you put a house on fire and that too when somebody is living, don't you think that there is a likelihood that somebody would die? If somebody doesn't come for the rescue, definitely the people who are residing in that house are definite to die, isn't it? So you can't expect every time hearing his hue and cry, some good Samaritan will come to you, come to your rescue, and then they'll put out fire and all. There is no 100% guarantee to it, isn't it? Now, the only assurance that can be, there is all probability, high probability rather, somebody getting killed when there is a fire is in the knowledge of that person. Now, you can't say that, I am very sorry, my intention is not to cause death, but nevertheless I set fire. So, if you want to attribute some criminal liability, so you put me liable for setting fire, not for murder, not for 302. So, his defense for criminal liability will not be valid because it is in your knowledge that some house, if suppose that it is set to fire and somebody is living in it, and if you have a knowledge that you can't say that no, mere fire somebody will die, you can't say that. It is for sure that he will die or they will die, isn't it? Now that is the knowledge part of it. And reason to believe, I have every reason to believe, I have all reasons to believe, previous experience of mine, or I have seen somebody's house set to fire and all people living in that house died in previous occasions. So I have my own reasons to believe that if I put fire to some house, somebody living in it are definite to die. So that means I have reason to believe, I am intending to do it, and I have a knowledge. So when you have all these three elements, you cannot just say I am innocent and all. So you criminal liability is definitely attributed to you, and then you are said to have this kind of act, and it is deemed that your act is done voluntarily. So that is the meaning of the word voluntarily. Natural and probable consequences of the act. A man is presumed to intend and know the natural and probable consequences of his act, and therefore in performing the act he voluntarily causes the consequences. You can't say any man of common prudence, he is supposed to know the natural and probable consequences of a particular act. So what is the natural and probable consequence of setting somebody's house at fire? It is but natural that effect is going to be death only. Nothing short of death will happen. If suppose you put fire a house and a small boy is sleeping inside the house, and then and that to night. See the wording in the example. It is done in night. Night in the mid of the night, in the flea hours of the night. You can't expect somebody to be alert, opening, gaping their eyes and mouth open and all. Nobody will be awake. Everybody will be so deep asleep that even if some attempt is made on him, he will not be able to run fast because he is half asleep. So you cannot just say this, you cannot take any kind of immunity, and this is the meaning attached to it. Now, causes intentionally or knows or had reason to believe to be likely to cause it. So when these elements of intention, knowledge and reason to believe are associated with your act, then it is definite that your act is done voluntarily. So we have done with voluntarily, we have done with the valuable security, we have done with injury. So let us move on to the last segment of our lecture, that is section 34. Now it doesn't specify, the heading is not common intention, but it is going to do something with the common intention. So let us first read what the section defines, then try to understand each word one by one, then come to understanding what we exactly mean by the common intention. Now, acts done by several persons in furtherance of common intention of all, then the liability of each of such person for that particular act is as if it were done by him alone. This is what is given under the definition of 34. Now let us try to understand each word specifically. Now acts means several persons, means there are group of people who are normally criminal act, criminal liability can be attributed to the person who has done that particular act. That means when somebody else is doing a criminal act, you can never be made liable for that act. It is the general rule. But then it is 34 is in contrast to the general concept of individual liability. It talks about the group liability. What is group liability? Act which is done by somebody else, you are made as criminal, you are attributed the criminal liability as if you alone have done that particular act. Now, how can you justify this? Now, what is the group philosophy? What is the mass philosophy? So if you are single, you will be afraid to do an illegal act, isn't it? Now, mass hysteria, they say. You are a group of people, you get strength from the masses, you get strength from the group, and you will be encouraged, you will be supported, you will be given protection, you will be given moral support. So all these facilities are there if you are doing a particular act in group. So all the more if you are doing an illegal act, you get all support. So you will get all encouragement. So that is the reason why this common intention has to be understood, and then this will say contributed liability, joint liability. So that element is brought in. Now, what does it say? Acts done by several people. That means one of the ingredients that go to make the definition is that it should be several persons, and then there should be some act that is to be done by them. So why are they doing this particular, all the group of people, why are they doing this particular act? In furtherance of a common intention. So they have a common intention. In order to execute that common intention, they are doing this particular act. Why? We are again talking about the intention and then act. Now, any crime will happen when it has two elements in it. What are the two elements? What are the two elements? What are the two elements? The first element is mens rea. The second element is the actus reus. Now, we know the actus, the mens rea can take different shades. One such word that can be attributed to mens rea is intention, isn't it? So, when I have an intention, which is illegal intention, a criminal intention, I am alone responsible and I will be made criminally liable for that particular act of mine. Now, if other person also has got a intention which is also the same, that means both of us have a single similar kind of a intention. Now, when will this intention become common? I keep my idea, my intention myself, the other person keeps his intention himself. Do you think that common intention can be made out of that? No, because common intention can be made out only when there is sharing of ideas. That means if for sharing ideas I need not be physically be present over there. It is sufficient for me take my mobile and then try to talk to the other person and tell him that I have designed this particular idea in my mind, because the enemy is common to both of us. You also have an enemy, I also have an enemy, and both the enemies seem to be a single person, and I have this intention because I am not happy. I want to clear my enemy, I want to eliminate my enemy. That is the intention I have now. And what is your idea? And that person also happens to say the same thing. Yes, you have taken my this thing idea. I also have a similar type of idea which is coming to my mind, and I also have the same fellow as enemy. So why not we do something together so that it becomes easy? It is easy, and instead of one person, if both of us do it, it will be very easy for us to do away with him. So this is the idea both of us have independently, and now after communicating, we now said to have shared the common idea, common intention, and now it becomes intention is taking the shape of a common intention because it's being shared. Now both the minds are agreeing. Both of us have the same mindset. Now the idea has been shared, a plan has been designed, and then we have hatched out a plan. What is the part you play and what is the part I play? So I say I am a senior citizen. I may not have all the courage and I am also feeble. I cannot run around. So what I'll do is I'll guard that place, and if somebody is coming on the way, I'll tell you that no, you be careful, somebody is coming, and then you alert him. So I'll take up that role, and you are a strong man and age is at your disposal, so you do the actual act. So that is the agreement that we make, and that is the common intention that both of us shared. So both of us are now proceeding towards the spot where we want to execute the action. Now, as agreed upon, I am guarding against the scene. That means I am staying a few feet away from the scene, and then I am vigilant over there. And while my friend or the other person with whom I have shared the idea, he goes and executes the offense. Now, in defense, tomorrow I should not be telling that, see, what is my role? I have not done anything. I have not executed that act. I was only merely guarding the scene. And he is the one. If you want to attribute the criminal liability, attribute to him. If you want him to be punished under 302 since he has committed a murder, you punish him accordingly. Why should I also be punished under the same act, under similar punishment? Rather, I should be given a lesser punishment or no punishment at all. If I go with this kind of a plead, then our pleadings, my pleading will not work. The reason is that we have shared this. There is a previous plan. Both of us, in our own might, the acts may be different. The acts that we are doing, acta serious, may be different. But then the intention, what we wanted to do is the same. It remains the same. And then there was previous meetings of mind. So we both of us shared the common idea and we wanted to execute it. What kind of act you have done in the actual execution is a different matter altogether. As long as both of you are sharing, it becomes a joint liability, it becomes a constructive liability, and this particular act or this particular section of 34 which talks about the common intention, and it says if this common intention is used in furtherance of a in furtherance of this common act, if you are executing an act, then for that act both of you are liable. Jointly you are liable, as if you alone have done. Even if you have not done anything also, there is a legal fiction, there is a legal friction which tells that it is a deemed kind of a legal fiction, that even if you have not done actual act of murdering somebody, yet you are liable for that. That is, it is constructive liability or joint liability. The whole principle of common intention revolves around the concept of joint liability or constructive liability. So no pleading or no pleading on your part that you have done a minor act whereas the other person has done a major act, and then accordingly the punishment should be graded. If you say that, it will not be valid anyway. Your pleading will not be valid, it will not be considered. But on the other hand, court strongly believes, or there is a fiction, legal fiction, that even if you have not done that, but then you will be deemed to have done that, and then that common liability will be fixed on both of you, and both of you will be punished for the act of murdering. Though you have not actually involved yourself in the murder also, yet it is deemed in the eye of the court that you also have done, because you have equally shared the common intention, you have equal intention, and immaterial that what act, what part you have played in the entire transaction, yet you are also liable for the same kind of punishment, is what is the essence of the entire section, namely called the section 34. Now, if you try to understand What is the object? Why the legislators? Is it without any thinking and without any application of mind they have done that, or deliberately they have done that? What is the objective? What is the mind of the legislator? Why they have enacted this particular section in this particular fashion? Now, intended to meet a case in which it may be difficult to distinguish between the criminal act of individual members of a party. That means there is a gang and you are not able to discriminately distinguish one act of the individual in the party with that of the other. Then if it is indistinguishable, then what you can do is you can only attribute what is known as the joint criminal liability for that. Now, another situation is that what exactly is the part played by each one of them. If you are not very clear about this particular aspect also, then in that case also it will be very difficult. So this is the objective of the class. Now, why all are deemed to be guilty in such cases? Simple logic, which we have already discussed. That is, the presence of accomplice, that is the presence of your co-accused or somebody who has a similar kind of mindset will encourage you. It will give you support. It will protect you. It will also give you a lot of your motive gets boosted up, isn't it? So, for these reasons, now the legislators rightfully thought that giving punishment, equal kind of punishment for all the gangsters in a particular group when their common intention is to commit a particular crime. That means in furtherance of a common intention, if all the gangsters, all the members of the gang are doing this a particular major act, then irrespective of the minor actions done by the individuals, it is immaterial. But then what is ultimately important is what is the ultimate and major act, that is the effect of their act is what matters. And if that is a murder, then each individual, suppose the group is consisting of, let us say, 5 members, A, B, C, D, E, and ultimately the cumulative action of all these people resulted in the death of the person, let us say X, and when attributing the criminal liability, you can say that A is equal to B, B is equal to C, C is equal to D. That means what? There is a common kind of a punishment that can be given. Irrespective, A may be only guarding, B may be catching hold of the hands, C may be, C may be just closing his mouth and all. These may be minor acts, but then what ultimately matters is if D is responsible in stabbing also, you cannot just say you punish only D, don't punish rest of the people. You can't say that. Now the ultimate major effect is death. So you will be A, B, C, D will be only given the punishment for 302. So 302 is for murder, isn't it? That punishment is murder. But though you have done minor acts, it is immaterial. As long as the ultimate final effect is death, all of you will be punished only for death. That's what it means. Every person engaged in the commission of a crime is held responsible. That means you alone, as if you would have done the murder, what kind of punishment would have been given to you? It is the murder punishment. That is 302. Under that section you will be punished. So even if your role in that particular gang or group is only a minor thing, yet you are also punished as if you alone have done that particular murder. That is the meaning of that. So the group liability or joint liability, vicarious, whatever name you try to give, now that you can see not only in 34 sections ranging from 34 to 38, and in 120A, 121A, then 149, 396, 460, in all these sections also you will see this kind of wording that is being used, that is the common intention or joint liability or vicarious liability. Now by taking these examples, you can categorize the acts into as many as 5 categories. What are the acts where you see the common intention, common object words have been used? Now, criminal act which is done with criminal common intention, that is category 1. What is category 1? A criminal act that is done with a common intention. Now, these kind of acts can be grouped under sections 34 to 38, where you see common intention is the word that is being used. Now, the second category of offenses are those which are committed with a common object. So common intention is something different from common object. We'll see what common object is in further classes, but time being, just understand that second category of offenses are those kind of offenses where they are committed with a common object of unlawful assembly. So this definition you will get in section 149. Now, the third category of offenses that you can see these words common intention, common object are seen is again the persons charged for criminal conspiracy. That is, any conspiracy against the state is a very serious offense, and this type of offenses are dealt under section 120A and 121A, 120A and 121A. So these are crimes against hatching a conspiracy against the state and then trying to topple the government and all. These kind of offenses are against the state, and they are very serious offenses, and there also you have the common intention word being used. Now, in dacoity also, somebody is trying to do the dacoity and then thereby also commit murder, then you also will see that this particular word common intention and common object being used. That is section 396, where 5 or more persons conjointly in the commission of a dacoity commit murder of somebody, that is coming under section 396. Now, the fifth category is one where persons are jointly concerned in committing the offense of a house trespass. This is legal house trespass or house breaking at night. So that is dealt in 460. Then what is the principle? Now the principle is very simple in 34. It creates no specific offense. So see, if it would have denoted a definite definition for crime, then it will not be included in the definition section under definition chapter 2. So the very reason that it has been included in the definition chapter indicates that it can only give a definition clause. By itself it cannot be defining a crime. So no specific definition of a crime it is giving, 34. But whereas when you say a common object as given under 149, definitely it is going to specify a offense. So 149 talks about common object, whereas 34 talks about common intention. So we should never get confused between the words common intention and common object. Common intention is the word that is used in section 34, whereas common object is the word that is used in the 149. In order to understand what is common object, then we need to go back to section 141, where what is a common unlawful assembly, what is an unlawful assembly is defined, because common object is the one which is going to be done by an unlawful assembly. Unless until you understand the definition of unlawful assembly, you will not be able to appreciate the definition for the common object that is being achieved by the unlawful assembly. So for that reason, a conjoined or co-jointly, if you read both these sections, that is 141 and 149, then you will better understand the concept behind the common object. Now, as far as the common intention is concerned, it only lays rules of evidence, and by itself it will not give you any definition of a specific offense. That's what you need to understand. Whereas when you talk of common object under 149, it is definitely going to give you a definition for a specific offense, isn't it? Now, the minimum number of people that should be there in the gang, though not explicitly it is given under 34, it says acts by several people. So since it uses the word common intention, you cannot have a common intention when you alone are thinking about an intention, isn't it? it requires a minimum of 2 people in order to share something between you, isn't it? So minimum that is required in order to share something, you require 2 people. So it is but commonsensical that though the law doesn't explicitly give you the minimum number, it is implied that for sharing common intention, at least 2 people should be there. So that's why the minimum number of people that should compose the gang in case of 34, it is though not explicit, understanding is minimum 2 are required. Whereas in contrast, under section 149, if you see the definition of the section itself is starting with 5 or more. That means what? The minimum number that can be there in order to do a thing with a common object, the minimum number in the gang that is required is 5. And if you see the maximum number in both the sections, you don't see anything which gives a maximum number. Several people, both of it says, in one case it says 5 and more, as in 149 it says 5 and more, but in 34 it says several people. Since it says common intention, now by understanding we can say that the minimum number that is required is only 2, and it can be shared by several people. Several people, there is no limit. It can be ranging from 2 to any number, isn't it? So that way both the sections, they don't specify the maximum number, is what you need to understand. Now then, Lay's rule of each of them will be jointly on the principle of group joint liability. So both these sections rely upon joint liability. That means when group are doing it with a common intention, it is but natural whatever criminal liability that you would like to attribute to one person, it will be the same for all the gangsters who are the members of that gang. That's what it means by joint liability. Now you are doing conjointly, you are doing an act that is illegal. Now for that, the punishment, if you see, that will be shared equally. Since you are sharing the common idea, you also please share the punishment also equally. That's what it means. Now each of them separately, as if they have done that particular act separately, each one will be liable for constructive liability, as if the act is done alone by him. That's what it means. Now if you see, look into the ingredients. If you want to make out, if the prosecution has to make out a case against somebody under attracting the section 34, now as many as minimum 3 ingredients are required. What are these 3 ingredients? Number 1 is a criminal act must be done by several persons. That means an act should be there and there should be several people and they will be doing the act. Then there must be a common intention of all to commit the criminal act. That means prior to doing the act, there must be the meeting of minds. They must have shared the ideas. That's how it has become a common intention. In furtherance of the common intention, you all assembled at one place, you carried the deadly weapons, you have gone to the spot, and each one of you, the act that you are doing may be not similar, it may be different, but nevertheless you are executing this act in furtherance of a common intention. That means all of you intentionally wanted to do it, you wanted to execute that. So that is what making you as a group, and as a group you are doing, and whatever a single person does also, that can be attributed to all others. So there must be participation. Whatever may be, the act may be as small as guarding near the scene, but then what is required is participation, engagement is what matters. If you want to be made liable, if somebody wants to attribute the criminal liability to you, that you have a common intention, that what is the action you have done in that particular group activity is immaterial. It may be very small, and activities of each of the gangsters may be different, but then ultimately what is the resultant, what is the final major act that has been committed, what matters. Now example, one may be standing as a god, as I have said, to prevent a person coming to the relief of the victim or facilitate the execution of the common design. So like that, the act done by each one of the member may be different. Now that's a different thing. But then as long as you are there, you are participating and you are engaged, that's what it matters. Now, in physical violence, however, it is essential for that person who instigate or aids must be physically present at the actual scene of offense. Now, because actus reus is action, isn't it? Action, putting your intentions into action. So for that, at least you have to be physically there. So I have an intention, I am sitting in my house, and then you cannot say just because I also shared the common intention, you cannot make me liable. You cannot attribute the criminal liability to me because my intentions are not getting transferred into action. I am not physically there. A physical violence has to be done, and I am not there. I have only shared my idea. You cannot make me liable for that. So you have to be physically be present over there in order to execute that action. That's what it means. Commission of offense is the culmination of the joint criminal venture. That is, you are doing a common venture. In that, it is the action of each one of them is the resultant of that particular major act, and then the major act is the major thing, main thing, based on which your criminal liability will be fixed. That means what? Simultaneously, there is a consensus of mind of all the persons to bring everybody to that particular place, and you have all acted cumulatively, and that resulted in the final result, that is the death of the person. So such consensus can be developed. It need not be their prayer, but then when you all join at one spot, you suddenly get this kind of consensus of mind, and then each one is designed one act, and that they are executing that act, and ultimately on whom you wanted to attack, you are successful in doing that, and then you have done him to death. So that's what is the common intention. Now, what exactly is common? How will you understand it? Now, I said prayer consent, that means there is a prayer agreement, prayer meeting of minds, and then prayer participation of all. This all been agreed upon earlier only. That means before you execute the action, if before you put your intention to action, then all of you, there is a sharing of idea, there is a common intention, a group share their ideas, and then each one what is the act to be performed, how you should participate, what kind of weapons you should carry, and if it is composed of, let us say, A, B, C, D, 4 people, what A has to do, what B has to do, what C has to do, it is all agreed upon. It is a pre-planned kind of an execution. So that is what is known as common intention. And act of each participant may differ. As I said, it may not be similar or it may not be the same. A may be doing a minor act, B may be doing yet another minor act, all minor acts by 3 of you, and ultimately D may be the person who is responsible for killing. So there may be difference of acts that are being done, but then what ultimately matters is the cumulative action of all of the gang members. The ultimate thing, cumulative action of that is resulting in a very big major act, that is the death of the person. Now, because the person died, there becomes a 302 case, and for that 302, all will be responsible. So whatever punishment that is there under 302, all of you will be eligible for that punishment. You cannot take any plea that I have done only a minor role, I have not done a major role, so accordingly my punishment should be graded. You can't take that plea. But since you are a gangster, gang member, since you have shared the common intention and you are doing this act in furtherance of this common intention, yes, you are also jointly liable, is what is the essence of 34. So let us take an example, then try to understand. A is an accused, for example. A is an accused in that particular crime, and he goes with others like co-accused. Who are all the co-accused? Along with A, there is B also, there is C also, and they wanted to proceed to D's house. D happens to be a victim, and they wanted to go to D. And so what do they do? In order to take revenge of an insult by the brother of D. So brother of D, who is now the victim, his brother in earlier occasions, he tried to insult one of the one of the members, maybe A, B, C. So any one of them he has insulted, that brother of the victim insulted. So now they want to take revenge of that. So what did they do? They started opening fire on the members of the D's family. So D will not be alone in the house, since it's a residential house dwelling. So you also see that along with D, there are also family members. Now these people, they started firing. On whom? On D, and in the process even family members also, they came in between. So what has happened? They opened fire on the members of the family. Then shots of A did not hit anybody. See, all of them, they are not professional shooters anyway. They do possess license of the firearm, and since firearms are easily available with them, so they all of them carried the firearm, and each one of them started firing. It was so unfortunate because A is not a very professional kind of a shooter. So even if he tried to shoot at these people, none of the shots could hit the person. So shots of A did not hit anybody, but whereas shots of B and C succeeded in killing D. So they also started, all of them started firing, but it is so unfortunate. Intention was there with A initially, but they all shared that intention. It has become a common intention now, but all of them, they have their minds have concerted, and then there is a common intention that's been shared, and then all of them, they said, let us carry these weapons, since we are all license holders of firearms, let us go with the firearms and do away with D family. So accordingly all of them proceeded, their guns are fully loaded, and they started firing, and out of them A is not such a professional kind of a shooter. So even if he tried his level best to shoot at least the family members or at D, so he was unsuccessful. None of the shots of A could hit either D or his family members, whereas by fluke B's and C's guns were very effective. When they tried to shoot, they were successful in killing D. Now the point is, how can you attribute the criminal liability to each one of them is the question before the court. Now A is as much liable for the offense of murder as are B and C. Why? Because we believed in the common intention. So before committing the murder, before carrying the weapons and all, when all of them assembled at one place, the idea was to kill D. Why? Because D's brother, once upon a time, he also was trying to insult one of them, and then so in order to take revenge against D, they all have the common intention of taking revenge against the D. So with that common intentions, when they have all gone, though A may be a failure, his shots might have failed in shooting or in hitting the person, but nevertheless he also shared the common intention. He had the strong intention of killing D. So that's the reason why we say A is also as much liable for the offense of murder as are B and C. So ultimately B and C succeeded, A failed, but yet the common liability, as I said, joint liability, because of section 34, you can attribute this and you can say that A is also equally responsible, though his shots could not kill D. That's the meaning. In the absence of common intention, the criminal liability of the member of the group might differ according to the degree and mode of the individual's participation in the act. Now, in the same example, if suppose, let us take a scenario, because in the illustration that we have given, we said common intention was there. Now, let us imagine the same case in a different situation where, let us say, common intention was absent. Now, if you have to attribute the criminal liability in such a case, what the law says is, now you cannot say or you cannot talk about the common or joint liability. Why? Because there is no common intention, there is no sharing of ideas, no sharing of intentions. So whatever is the degree of participation, whatever is the mode of somebody's participation, accordingly the punishment should be there. So this will happen only in case when there is no common intention. But had there been common intention, the first example is good enough. That means each one of them is equally criminally responsible or criminally liable. That's the meaning. Now, let us take the another example and try to understand how, if there is absence of common intention, how can you say that this is not coming under the 34. Now, let us take another illustration. This time we'll say XYZ instead of ABC, we'll say XYZ or the group, and with the intention of assaulting A. So they wanted to assault A and gave him beating. So each one of them, they gave good beating to him, and in the process, during the course of which X, who had previous enmity with A, X who has got previous enmity with A, stabs him in the abdomen. See, so A gave him a beating. See, the intention was to beat him. His intention, there was no common intention. Only A had that intention. A had the intention of killing him, stabbing him. Whereas all others have an intention only to grievously hurt him. Because it's only enmity not to the extent of killing the other person, isn't it? So each one, what I mean to say is, have a different intentions together. The act of stabbing is not done in furtherance of common intention of the group, because there was no common sharing of intention. A had a separate intention of killing him, whereas XYZ have a different intention, that is, they wanted to only take revenge and then only wanted to beat him. It is only A who wanted to kill him. That means there is an absence of common intention. That's what you need to understand. And if you have to attribute criminal liability in such a case where the case doesn't warrant any presence of common intention, rather absence of common intention, then what you can say is you cannot punish all of them, X, Y, Z and A, with the same criminal liability. That's what is given as an illustration. Now, hence, Y and Z could be liable for simple hurt because there was an intention to beat. So, whenever there is an intention to beat, you become liable for under 320. That is the causing of hurt or grievous hurt. Now, but X for causing murder of A. See, X can only be given punishment for 302. Why? Because he had the intention of killing. So far as A was concerned, court held that the blow was given with deliberate intention on the head of the fallen and helpless man. Now see his intention. See, one blow when A gave, the other person, the victim, has fallen onto the ground. There is no difference being offered when his head is hit, that he has become unconscious, he is helpless, he has fallen to the ground, and there is no way that he can raise and then hit them in retaliation, isn't it? Now, in spite of knowing that also, now he is so vengeful that he again stabbed him. That means what? The idea is not shared. Common intention was never there. It was absent. Now, it is A who bore lot of grudge, lot of enmity, and all others simply wanted to hurt him or make some injury so that he will be set right. So, there was no common intention of killing the person. Only intention that was there with all of them was to beat him. That's it. But the exception was A. A had another kind of an idea altogether. Now, when all of them come, let everybody will encourage me and I'll only stab him. Because the intentions were never shared. They never had the common intention. So, the only common intention that could be attributed to them was the intention to beat X with weapon, which were likely to produce only grievous hurt. It will never cause murder. Therefore, we can say that they were not guilty under 302. So, they were not responsible for killing of the person. The person whoever that is responsible is only X, because he has the strong intention of killing. So that, how can you know that? Because he has used a knife instead of stick. He carried a knife, and with the knife somebody is stabbing, there is surety of death, certainty of death. So now only X can be punished for the murder, that is under 302, whereas all others whose intention was only to beat the other person, the victim, hence they should be punished under 323, either the hurt or simple hurt. Now, what do you understand by the participation in the criminal act? Now, it simply means that the criminal act conducted precedent in order to fix the joint liability. That means there is a conduct. What is the conduct? There is a common intention. That should be precedent. That means that should have occurred before the actual incident. Then only you can fix that means there should be active participation for fixing up the joint liability. So what do you understand by participation? Overt action, some kind of an action indicative of criminal intention to sustain conviction under 34 has to be there. That means however little that act may be, however minor that act may be, some explicit overt action should be there. If you want to attract the element of common intention under 34, the prosecution has to prove or has to explicitly show an act of overt act. If you want to put somebody under 34 common intention, then overt action is a must. So group must be present and take part in the commission. Group as such has to be there, and each one of them should be committing one act or the other. Now, what is the test? If you want to convict somebody under 34, what is the test? What ingredients should be there? Only then you can say common intention can be attracted. What are those elements? Now, some of the co-accused may be acquitted, provided it can be proved either by direct evidence or inferences that the accused and others have committed the offense in pursuance of the common intention of the group. Now, if you want to prove that, you have to show some overt action, and this overt action is in pursuance of a common intention. If we can prove that, then you have proved a 34. Now, you have to understand the difference or the distinction between same act or similar intention or common intention. There is a subtle difference between the common intention and same intention or similar intention. These are little different. Now, to constitute, if you want to book somebody under 34, you have to prove what is known as the common intention, not the same or similar intention. Now, it is necessary that the intention of each person be known to all of others. Now, if you have an intention, keep it for yourself. It doesn't mean that you are both of you have a common intention. You have a single individual intention with you. The other person has another individual intention with him. These intentions were never shared, so they cannot become a common intention. Now, in order to become a common intention, what it means is there should be sharing of ideas and sharing of intentions. Only then it becomes common intention. Now, we have to distinguish between the very important thing. Now it comes to common intention and then common object. I said common object, we have a definition under 149. I think this is a little important from examination point of view. Probably tomorrow's class will understand the differences between 34 and 149. 34 speaks about common intention, whereas the section 149 speaks about the common object. So for today, that's all I wanted to discuss, and tomorrow's class, same time, same link, will assemble, and then we'll continue with the 34 and 149, the differences between the two sections. Let us leave the meeting now.